If you have a debt collection lawsuit, you're going to want to watch this video. If you have a debt collector who is attempting to collect the debt from you, you're going to want to watch this video, because if you do not respond, you could end up getting a default judgment, or if a debt collector is attempting to collect from you and you don't respond, you are going to allow them to place the information on your credit reports, and then the next step that they could take is to take you to court to sue you to try to collect on that money. So I want to give you some of the stats that I've read through on this website. It's showing that 70% of all of the civil cases from debt collectors are ending up in default judgments. Now, it can vary from, state to state, county to county, but when they average it all up, 70% of the default there's a 70% rate of a default judgment. So a default judgment occurs when an individual does not show up to court at all. They just disregard the summons. It's maybe delivered and put in your hand by a process server, or maybe you got it in the mail, or they left it on your doorstep. And they're allowed to do different, serve people different ways in different states. So you should look at the laws in your state regarding serving you court summons. So 70% default rate when you average up all of the reporting states, and not all states are reporting, which I think that this should be something that they should be required to do, because we pay our tax money to keep our court system working. They should, any money that's utilized from taxpayers, they should it should be mandated that they give reports. And some of these states do report, so I thank them for being able for doing that for us, because it allows me to be able to share this information with you. Now, in my state of Wisconsin, 95% of the cases end up in default judgments. So 95% of the cases that are in my area, and 99% end up in a judgment. And they end up in a judgment because the defendant just didn't know what to say, didn't know what to do, and they basically just did not have any defense. So 99% of those cases that ended up in either a default judgment or a judgment was not because the debt collector proved their case. It was because the defendant did not have any defense, either put forth by showing up for because they got a default judgment, they didn't even show up, and then the individuals that did show up just did not have any defense. So before we get into the solution on the things that you need to watch out for, so you don't end up getting a default judgment or just a judgment if you show up for your case, we're going to talk about the things that you need to watch out for, but I want to show you some numbers. And I want to look here at the state of Texas, and the reason why I want to pick the state of Texas, I'm going to look at the report here, is because, number one, they've updated 2023, so they got their 2020 to 2023, and they had and this is just Harris County, not, there's other counties in Texas. This is just Harris County. So you got from January 2020 to December 2023, 214,057 cases. 90.2% of the defendants did not have legal representation. So remember, even if they have legal representation, a lot of these cases end up having to go straight to settlement. Not to say that lawyers won't fight for them, but when I dig into the numbers, the majority of those cases ended up going into a settlement phase. And that's not because the attorney does not want to fight for anyone. It's just because it's going to take a lot, and people just don't have enough, a lot of money to pay attorneys to continue going back to court over and over and over again. They come to the realization that it might just be better to settle. And that's why a lot of those cases, when they end up having representation, they end up settling those accounts, which there's nothing wrong with that. On the flip side, though, when you don't have any representation, then that's really saying that you don't have any defense. And I just told you that 99% of the cases end up with a judgment because the defendant did not have any defense, didn't put up any defense other than just denying everything. And then they had 32.3% ended up in default judgments. Now you might be saying, well, Steve, in Texas, why is it 32.3% of the cases end up in default judgment? I have an answer for that. The reason why 32.3% end up in default judgments, and the number is not higher like it is in my state, is because in Texas they do not allow garnishments. Now, I want to go over the 4 states that do not allow garnishment, but I'm going to tell you what does end up happening. So just because they don't allow garnishments, it does not mean that you're out of the woods. So the 4 states that do not allow wage garnishments, North Carolina, Pennsylvania, South Carolina, and Texas, they do not allow wage garnishments. So this number is very low. Well, that's still extremely high, but it's low in relation to like my state of Wisconsin, because the judges are going to, at a minimum, going to try to allow people the opportunity to defend themselves, to come in the court. They're going to have another hearing, and they're going to say, okay, we gave you plenty of opportunity. It's going to be more than where if you don't show up and they just automatically give you a default judgment like they would in my state. They're going to make the debt collector, jump through a few more hoops, because they know that this potential outcome could happen. What is that potential outcome? The potential outcome that can happen is that they can go into your bank account. I can tell you from personal experience dealing with clients who come from Texas who had gotten a default judgment, the number one issue that they have, the number one problem that they have when they come to us, is that their bank account has either been garnished, where they took the money, or their bank account is frozen and they don't have access to their money. So that is the reason why, and we get that also from the other states where they cannot do garnishments. The majority of the YouTube subscribers who contact us, or people who come across my website or see, one of my videos or something on another platform, their main issue when they got a default judgment was that they woke up one morning and their bank account was frozen, and or the money was garnished. They were able to just take the money out of the bank account. In our state, because even though they have 25%, or in other states 25% of your paycheck taken away in a garnishment, in relation to having all of your money taken out of your bank account in a garnishment, it's just even though both situations hurt, both situations can make you feel like it's the end of the world. Both situations can make you feel like, hey, I just want to quit and file bankruptcy or whatever. We both have to admit that if you wake up in the morning and they garnish the money out of your bank account, that's going to have more effects on the way that you feel, number one, throughout the day, and then effects on you being able to manage to pay your household expenses, at least until you get another paycheck and recover. And just so you know, for your information, FYI, if they have a writ of garnishment of your bank account and you do nothing about it, and let's just say that you owe them $4,000 and you have $2,000 in there, and in your next paycheck you're going to have another $2,000 put in there, the bank will give them the $2,000 as long as they have that order in hand at the bank. As long as they have it and it's uploaded, they're going to take that money and give it straight to the debt collector. So this is what in Harris County, before we get into the things that you need to watch out for, if you have a debt collection lawsuit where they're trying to sue you for money that from a debt that they've purchased, that they've paid pennies on the dollar for it, and they can legally try to sue you for the money. So there is no, I want to get rid of the misconception that just because a debt collector buys your debt and you think because someone said it on a video, or not you because you watch my videos, but you might have just seen someone mention that and it put a thought in your head like, oh, I don't owe you because there is no contract. If you don't go to court and you don't defend yourself, the consequences of that is you will end up getting a default judgment, or you will get a judgment if you don't defend yourself. And I'm going to give you some information on how you can defend yourself. But so we got LVMV funding. They had 37,867 lawsuits. Let's just say, on average, let's just say that the debt collection lawsuit was $3,000, and we're talking about 37,886. We're talking over $340 million. I'm looking at my calculator. $340 million. So do you think that they want to just play around? Like, this is not a game for them. These are billion-dollar, if not multi-million-dollar companies, close to $1 billion companies. So this is not a game. So, this is not a game. I'm just gonna say it that way. This is not a game. So they are taking people to court. They are investing money with the fees that they have to pay for all 37,000 defendants that they're going to sue. They have to pay a fee, and they want to make their money back, and they want to make money on top of it. So this is not a game for them. So, and we got Midland Credit Management, over 25,000. Cons Appliance Incorporated. That is a debt collector. Cons Appliances Incorporated. I'm not sure if that's debt collector. Let me look that up. My apologies. Cons Appliance is a major appliance store in the state of Texas. So I do apologize for that. And it says here their reported revenue was $1.2 billion in 2023. So they're just a major appliance store, and they do their own collections. They're not hiring debt collectors to do their lawsuits. So what they figured out in the state of Texas, what they figured out is if they get that default judgment, that 32% on average default judgment, what does cons do? They garnish the bank account. We got Portfolio Recovery with 21,000, a little over 21,000. Bank of America, 8,000. Jefferson Capital, Citibank, J.P. Morgan, Credit Corp Solutions. We know that they are a debt collection company. And let's look at this one here, Opportune Inc. Okay, Opportune Inc. is a direct lender, so they're out of the state of California. It does not show how much revenue they had. It says that they were founded in 2005. But the reason why, so you can see they got over 5,000 lawsuits. Reason why you'll see companies go ahead and do the lawsuits directly in the state of Texas is because they're going to be able to garnish the bank account. So you had the proof right here, 214,000 cases. And the reason why you'll see a lot of original creditors suing directly is because they're going to be able to garnish the bank account directly from the individual. So that was a good example. Let's look at Philadelphia. So you see here, the number went up, even though, now this number here, it says here 44.5% resulted in default judgments. They may have, where the judges do not feel comfortable just pushing out default judgments. But these numbers here could be higher, but I like that they did get all the way to 2023, December to 2023. You can see LVMV funding, Midland portfolio. You can see that it's kind of flipping, and you can see that some of these companies, Discover, we start to see the direct, the normal companies. So you usually see Discover, Capital One, American Express. Those are going to start with the other states where they're going to start doing their own lawsuits, and you're going to see majority of the other debt collection companies doing lawsuits, doing the lawsuits in those states. But we could even still see here that you got 94.1% did not have legal representation. So when you put these numbers together, it's going to be a high number of judgments, period. A high number of judgments, period. And you can see 44.5% ended up in default judgments. So let's see here if we got some other data. They're showing the areas that they had the most cases in. They got some other reports. I'll put a link to this here. This is something that you should pay attention to. Here's something here that you want to pay attention to. Look at this here. It says neighborhoods by racial majority. So it says 36% of the neighborhoods, 24.8% of lawsuits. Black neighborhood, 36.3% of the neighborhoods, and it has 46.5% of the lawsuits. And then you have Latin, 6.5% and 7.2%, Asian, 0.3% and 0.1%. Now, so you can see here. Now, let me tell you why this here, these numbers right here could be looking this way. So even though this is still a high number, and because I actually deal with clients that are from various communities, I could tell you that people in all communities are being sued by debt collectors. But I can tell you that in certain communities, debt collectors take another tact. And something that I see, and I don't have any data to show that my feelings on this is 100% accurate, but you can kind of come to your own thought, your own answer on this. That's the better word. So what I see, and this is in all, they don't really have to put black and white and Latinx and all of this. What I could tell you from dealing with my clients, from dealing with people who contact me from YouTube or whatever way that they come into contact with us, is that it's mainly where the debt collector feels that there is a less of an opportunity of an individual being able to defend themselves in court. And also something else that happens is that in communities where people have resources and they're confronted with these lawsuits, if you have resources and you don't want to end up going to court, you're going to try to, you come to a quicker realization that you're going to have to do something to resolve it, and it doesn't get to be a case. Maybe it becomes a case and then you resolve it and they dismiss the case. This is something that I don't know if they report a lot on those. Like, they report on the judgments, they report on the default judgments, but they don't really report on the cases that ended up getting resolved that did not end up becoming a case because the individual had the resources or, contacted a company like mine to go ahead and resolve this before it got to be 100% up into the courts where the judge and it's got a case number and all of this stuff. And there are times where they do give an individual an opportunity where they'll say, okay, we're going to take you to court if you don't want to deal with this, and they give the individual the opportunity to work something out, but they will draw up all of the documents and say, we're going to give you like 30 days, to respond to our potential lawsuit. Now, they cannot pretend like they filed the case against you to try to scare you into responding or doing something to resolve the case. They cannot do that. So I want to be clear about that. But they can draw up the paperwork and say that we're going to present this to the court. Like, they have to be 100% upfront with you about that. So let's talk about some of the things that you need to watch out for when you are served a debt collection lawsuit. So we want to look at the contracts that they provide, not only the contract that they provide from the original creditor, because you want to look at that to see if there's any issues that you maybe had with the account, because some of the times you don't even recall it because it could have been a couple of years ago and you thought that this was all done and over with, and all of a sudden you get this knock on your door and it's a process servicer asking, is this, asking your name, and then they'll say sign right here, and they say you've been served, and then you open it up, it's that credit card that you forgot all about, and it has a debt collector on there, and you're wondering, okay, they wrote it off or they have a written off, they have a charge off, that means that I don't owe them, they're going to get the money on their taxes. No, it doesn't mean that. It just means that they took it off their books, and now they're going to either be able to come after you themselves and by hiring a debt collector to do it for them, or they're going to sell the debt, and then the debt collector is going to try to come after you to try to collect on that debt. They're going to try to get all of the money. That's the business that they're in. So you're going to want to review your contract. They should give you your original contract that you had from the original creditor. You want to review that to make sure that there's no issues with that contract. Next thing is you're going to want to make sure that all of the signatures on that contract match. You're going to want to make sure that signatures across the board on all documents that I'm about to mention right now, and any documents that they put into your as attachments to your lawsuit, you want to make sure that everything is signed, everything is dated, and that everything is in a correct sequence. And what I mean by a correct sequence is that you can't have a bill of sale for your debt and then have another document saying that they transferred the debt, that it was transferred before they purchased it. You want to make sure that everything makes sense with the process of them buying your debt and then moving forward with all of the other documents. They can't have the documents that I'm about to mention right now. They can't have some of these documents before they even buy your debt, because then they wouldn't even have authorization to even have access to your private information. So all of that needs to be in a sequence, or there's going to be problems that you can point out when you make your affirmative defense against the debt collection lawsuit. So you want to look at that bill of sale. You want to look at what's called a conformity statement. And this conformity statement needs to be signed, it needs to be dated, and it needs to have proof of a witness or a what do you call it? When they sign, for some reason the word is not coming to me. It needs to be notarized. That's the word. Okay. And then attorney review. Look at the documents to see if they had any information on there that an attorney reviewed it. Most of the time, now this might, you may not be aware of this. If you've been watching my videos, you should be aware of it, is that most of the time attorneys do not review the cases. The reason why they don't review the cases, and I just showed you, is because the majority of those cases end up in default judgment, or the majority of the cases that no one has anyone there to legally represent them, so there's not going to be any defense against the case. So why go through all of the work of having an attorney review it when the majority of the cases are not even going to be defended properly? The next thing that you need to look at is the chain of custody. You want to make sure that all of the documents that they got from the original creditor, any paperwork that was signed, if it was transferred from one portfolio company and then transferred over to a debt collection company. So you got two different hands, which would also mean that all of the documents cannot be 100% verified from the debt collector who currently has the debt from the original creditor. There is a middle company in between. They can only speak to the documents that they receive from the portfolio company, but you want to make sure that that chain of custody is accurately showing on the documents that they give to you. Next thing is from the original creditor, and I spoke on this a little bit, the original creditor transfer affidavit authorization. You want to make sure that all of those documents are within your attachments with your court summons. If they don't attach those documents, how do you even know that this company, the debt collection company, can even legally come after you for that debt? There's plenty of court summons that I've reviewed, and they don't even have those documents in there. This is an incomplete court summons. They have not even, at a bare minimum, showed how they acquired the debt. Next thing you want to look at is the details of the assignment. And I kind of spoke on this also in the details of the transfer and the details of the sale. These are documents that they don't even intend on you paying attention to. These are documents to make it look good in front of the judge, to show that they do have and own the debt and that it was transferred the right way. But we always know that the devil is in the details, and you need to look at those details. And many times when we've reviewed those documents, it was out of sequence. It was even in some documents, it's shown that if an original creditor sold it to a debt collector, that they could not resell it to another debt collector. And I know that that might sound crazy, but they have given documents to defendants that actually stated that in there, and they never intended for anyone to read it. They just never intended for anyone to read it. Reason why they never intended for anyone to read it is because in Philadelphia, it states right here, 94.1% of the people do not even have representation. When you don't have representation, you don't have any defense other than, I don't know how I'm going to pay this, or other than, I don't owe the debt. And then they go about proving that you owe the debt when you could have a defense on multiple documents that they've put forth to try to build their case. And then 44.5% end up in default judgment, so there is no opportunity to defend against the documents that were supplied by the debt collection company. And those documents could be 100% inaccurate, 100% faulty, and because no one showed up and they ended up getting a default judgment, these companies are able to go ahead and collect on that money. And in the state of Pennsylvania, they're able to garnish the wages, which would be the next step. So if you have a debt collection lawsuit, if you're facing a debt collection lawsuit, you can go to my website, thecreditrepairshop.com. Links are below this video, and you can upload your summons in our live chat feature. There's a little paper clip there. You click that and you can upload a PDF. I would prefer a PDF, but if you have to send JPEG files, that's fine. It's all about trying to help you out of your situation or help you with some answers and some solutions. So if you have to upload it one at a time, go ahead and do that. It's more important to be able to get you the help. We'll tell you the options that you have available to fight back against a debt collection lawsuit. Even if you're being sued by the original creditor, there are options that are available to you. We would like to review it, and then we can get back with you on the available options that you have. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. That's the way that we repair credit. That's the way that we help people. If you cannot follow that process with us, please choose another company. If you need your credit reports and scores, go to the website your3scores.com. Link is below this video. It's very important that you know what's on your credit reports. And you're going to get TransUnion, Equifax, Experian credit reports in all 3 scores. All of the furniture, addresses, and information was going to be within those credit reports. If you have debt collectors coming after you early, you can avoid a debt collection lawsuit by simply responding to the debt collector the right way. I have 3 letters that you're going to get absolutely free. I do ask for a donation. I appreciate that. It helps me with my time that I dedicate to help you here on YouTube. Get my statute of limitations letter for debt that is past the legal statute of limitations to collect. If your debt is past the legal statute of limitations to collect, you do not have to do a debt validation or verification. You just need to notify them that they cannot legally take any legal action to try to collect on that debt. And then if it is past the legal statute of limitations, you can do a cease and desist, where they can just maybe send you letters in the mail, because they can try to collect from you. They just cannot take any legal action. And so you want to stop any calls, or maybe they'll probably stop even mailing stuff to you when they know that you have no legal obligation to pay them. The way that you know that your debt is past the legal statute of limitations to collect is to go and look at the statute of limitations to collect on particular types of debt for your state. Open-end accounts usually have a shorter statute of limitations period to collect than regular accounts like an auto loan or an installment type loan. Those are usually longer. When you look on your credit reports, look at the last payment date, and if it's 1 day past, 1 hour past the date for that statute of limitations, you do not have any legal obligation to pay, and that goes for original creditors and debt collectors. So grab those letters. The other letter that I give to you, the other 2, is a cease and desist collection activities letter, which asks the debt collector to give you all of the appropriate information to show that they have a right to collect on that debt. Also to prove the claimed amount that they're saying that you owe. This will either stop a debt collector, or it will prepare you if they decide to take you to court, because one of the things that they'll try to do is to say that you had the opportunity to respond to them. But if they didn't, if you only ask them questions a certain way to where they can kind of avoid responding, they could just go ahead and skip and take you to court. And you would have to deal with it in that arena, when you could actually have some information that they disregarded, that they actually violated the Fair Debt Collections Practices Act by not doing a debt validation or verification when you requested it in a specified period of time, and you would like to have their case dismissed based off of that, because they are required to do that. So I give you those 2 letters, a debt validation letter and a cease and desist collection activities letter. Link is below this video. Thank you for your time. Please like this video, because when you like this video, you help other people get help. I help you. You like the video to be able to help other people, so you're actually included in the process. Thank you for your time. Subscribe to the channel if you haven't done that yet. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.